Go bold at boldip.com.
Welcome everybody to the Bold Inventor Show. I'm JD Houvener with my co-host Matt Kulseth. Matt, good summer to you.
What is going on? Yeah, it's a great summer. It's going by exceedingly fast.
Yeah, it is. It is. You froze it for a second. We have you. You're dedicated as always. You're plugged in from the cabin up there in Minnesota. What are you up to up there?
Well, we have some friends and family up the past week, and now we're just playing card games today because it's raining.
That's really nice. You get to kind of relax, unwind.
Yep, we're gonna break out the Catan a little bit later tonight.
Oh, I love it.
And play that. Yeah, what's new with you?
We're doing some board games too. Trying to keep the kids busy. We played some Carcassonne. That's a French game, kind of you build the civilization with these little puzzle pieces.
That's cool.
And it's awesome. We did Yahtzee, lots of board games. I'm building stuff though in the backyard. I built a giant 480 square foot deck.
What?
Yeah.
Nice work. Way to go.
It's all flat and it's about 8 inches off the ground, so it's a floating deck.
Perfect.
It is still upright. Nothing has fallen down yet. And I just stained it yesterday. Really
fantastic.
Proud.
Way to go. Way to go, JD.
It's around this giant pool. And if I told you we had a pool, above ground pool as well. So I've been busy and sweaty in the backyard and on like project overload. My neighbor's like, wow, JD, what are you gonna do next? And for a lot of reasons I was laughing. His wife was probably like, oh, why don't you do something like that?
Why don't you get out there and do it out a pool or whatever?
Exactly.
That's awesome, man. Way to go.
Yep. So that's me. We're So I got one more trip left this summer. We're taking our kids to Lake Chelan end of the month, but this week, next week, we're heads down.
Nice. Yep. Same here. We're this week, next week, just busy kind of working, and then we're off to the Boundary Waters Canoe Area Wilderness.
Okay.
For a week or so with the kids.
Nice. That's good. Yeah. Get a final trip in before school.
Yep. Got to get a trip in for them before school. Perfect. That's right.
Cool. Okay. Well, we're here. We're doing our show. This is episode 104. We have quite a good following on YouTube, so we're live on YouTube, LinkedIn, and Facebook as always. No guests today, but yeah, you're stuck with us. We're going to be talking about trademarks and patents today. If you're watching this and you didn't catch us live, we are live every Wednesday at 1:30 Pacific time, so catch us next week. If anyone has questions, we will take those throughout the broadcast. I'll open anything that comes up, anything on your mind, business, intellectual property, patents, and trademarks. That's all fair game. I did pick out 5 questions for us to go over from Amira. She set those aside for us. So I've got two trademark and 3 patent questions.
Cool.
We can dig in there first, and I've got a Shark Tank critique for us to look at as well. And a little more relaxed format. We're not going to be rushing through it. Maybe we can take a look at it. But I will have to limit the amount of the video that I show, otherwise they'll cut our broadcast off.
Sure.
So, let me do this here. Phillip, I remember you. All right. We had you on a few weeks ago. Good to have you. Good to have you on. Fellow intellectual property professional. Let me put this here. So this is our disclaimer. As always, we're just talking about legal information. We're not giving any advice specific to anyone individual. If you do want to protect your invention, take a look and see if your brand or trademark is something to move forward with. This is the link for you to take for our weekly live link. So right there, have a look. Schedule a time with Dallas. He just took a week off last week, so his calendar's slammed this week. Serves him right, taking a week off. Yeah. It's like, you're gonna one way or the other pay the piper. But no, we have plenty of availability starting early next week for new discovery calls. Okay. Well, I think I'll take the first crack.
Yeah, sounds good.
At these questions here. Again, thank you to Amira Cardona at Bold. She's out there in the depths of Reddit and Quora and Facebook and LinkedIn, digging for all the questions because you're not all lining up asking them here on our live broadcast, which you're welcome to. Let's have a couple live viewers. Again, if this is your first time watching, we do welcome live questions throughout the broadcast, and Matt and I will take our best shot at those. First one here. I love it. This is like holding what's it called? No holds bar.
Yeah.
At the right. Here we go. Right to the gut shot. Can a patent attorney steal your idea before they help you patent it?
Sure, why not?
The answer is yes. Let's move on. Let's just move on. The answer is yes, and you wonder why I live so well. No, the truth is yes, but it would be the worst decision of that attorney's life. They have built up their entire career, gone to 8 years of school, maybe more with undergrad and any graduate degrees.
Hundreds of thousands of dollars worth of debt.
Dedicated your career to it. Bottom line is there's no opportunity big enough. It's just, what are you doing? You'd have to be such a darn fool. And that's why you take an oath. That's why you swear an oath to the public, to inventors, on top of the state oath that the attorneys take to obviously, duty of care, duty of loyalty to clients. The patent office makes you basically do the same thing all over. Trademark attorneys, have their state law oath and other, it's about integrity. It's about trusting. And oftentimes attorneys are the first line. You have to be able to trust someone, another human being, with whatever good, bad, ugly, exciting news you have. And on the patent and trademark side, it's usually good, fun, exciting news.
Sure.
To move forward and protect something, you do have to take that leap of faith and trust somebody. So I don't want to take this question totally as a farce. I mean, it is something that comes up. I know a lot of clients have considered, like, gosh, what do I do? I have to trust someone. So I would say do your research. Like if you're going to go have a serious decision about anything, if you're going to go hire a wedding planner, I mean, if you're going to go hire, a CPA, or you're going to go look them up. Who is the individual? Who's the founder? What's the company? How do they work? Testimonials. Look at the reviews. Talk to someone else. See if they're legit. Those are all things that you can do to kind of help maybe mitigate that risk against that individual or the law firm itself. You can go look at the state bar. That is probably the number one way to sort of verify, validate the attorney, make sure they're not under current, whether disbarment or if they're currently suspended. They're going to see all their disciplinary issues. It can come up. It happens to a lot of people. And do your research. Anything else you would add to that, Matt?
No. I mean, I can't think of any trademark examples where, at least I've been I'm sure it's happened, but I can't think of any where an attorney has stolen a client's IP, right?
Yeah.
The only thing I could consider where an attorney might own some of the IP is in the rare, not not recommended situation where the attorney, in lieu of payment, takes partial ownership of the company. Yeah. That's a whole other can of worms, and we obviously don't do that here.
No, we don't. I have heard of that being done, and actually, I just thought of another way, perhaps. But let's take that one. Let's just explore that for a minute or two. We have a longer format today, so that might be kind of cool to bounce us around. Where it's like anything else, you have like the repo man,
yep.
Right? If you're buying a car, that collateral is the car, right? If you don't pay your loan to the bank, you could have someone put a boot on it or drive it off. I've never had that happen to me, but it happens. They can reclaim the asset. Now with patents, it's a service, and so it's a bit trickier. You can't just go take the brain of the inventor. But when you have a filing, an actual definitive documented application or even a granted patent, now you have an asset. And if they have a bunch of money they owe you, they haven't paid you for your legal services, some attorneys use that as collateral. We don't, but I think that would wait. I don't think the word is steal. I think that's too severe of a word, but that you're right. That is an interesting way to do it. We haven't done that. We don't deal with that. We don't. We do our best up front to screen our clients and make sure that they are a good fit. And we don't take everybody on. If somebody seems a little bit too wily, want to put a lot on credit, or they're just not, financially secure enough, they're not going to be a good fit. And that doesn't end up being the problem. One other way I think that this could come up, that probably wasn't even part of the original question, is equity. So sometimes attorneys work for equity, and it's usually in terms of a business. So if the invention, the patent, is an IP, and trademark is owned by the individual at first, then they assign it to a company that they own and manage. And instead of getting paid money for legal services, the attorney can negotiate a percentage of ownership in that company. It's a little different, but I suppose there could be a situation where big breakup, right? And as part of that dissolution of the company, well, the attorney is going to want to get paid, and they want to get their share of equity. And part of that could be from the proceeds of a sale of the IP. And again, that's an extreme.
Yeah.
We do have a question here. Philip.
Great answer.
Philip's got a question. What are your thoughts on selection patents? Double patenting seems to be a key barrier, and I've never had any problems. Well, I think you've stumped me. I don't know what a selection patent is, Philip. I'm sorry. Double patenting, this is kind of like me going back to patent law class, right? Having to get a tough question from someone in the field. I don't have a great answer, Philip. If you could add some more color, maybe dumb it down for me, honestly. Give me a little more clarity on what you're talking about with the selection patents. Double patenting, I believe, from my memory, and obviously I haven't done a lot of practice in this area, is when you go for a continuation application and it has the same or similar subject matter, or if you have an initial patent that gets granted and you're going back for more, your own patent can act as prior art against you, is I think where that's going. So let's get some more clarity, Philip. Thanks for that question. Bosland, David Bosland. I'm pretty sure that's you. Unless there's another Bosland law out there, and then we have a trademark issue. Perhaps trademark issue. I've certainly done a lot more advance fee deposits than I used to. Okay, maybe this is in light of our not having to use the patent as collateral to get money. So, right, as lawyers, any professional makes sense. If you want to reduce your risk of having to collect money later, require some money up front in terms of either a retainer, it's called, or some sort of deposit, so you can bill against it, or have it be a portion of your flat fee. But yeah, thanks for that, David. All right, Matt, you're up, my friend.
Okay, let's do this.
Let's do one. This is from Quora. I can't say I've ever used Quora.
No, I don't. I see Quora all the time. Like, if I'm looking up something, right, it comes up. But I've never thought to be like, this is a great platform for asking questions. So I don't know where they get their questions or people submit them on Quora, but I don't use it either.
Here we go. What are my rights where another company has trademarked a name that I've been using for 8 years?
Yeah.
What are your rights?
It depends. You may have pretty strong unregistered common law rights to the name, which you could potentially convert to a trademark registration at the USPTO. Whether or not you can apply for the trademark and successfully cancel the third-party trademark depends on a number of factors. The primary factor is going to be, one, you're going to have priority of use before the other party. So you have to go to market, begin offering products or services for sale before the other party either filed their trademark application or began their own product and service offerings. So assuming you have prior use of the trademark, so priority of use, at that point, you need to look at and see how long this third-party trademark has registered. If it's been 5 or more years, they might have filed what's called a Section 15, which makes the trademark incontestable for priority of use purposes. So you might be denied based on that third-party registration. So I would recommend talking to a trademark attorney. They'll be able to, more accurately do some research and determine whether or not you have the ability to enforce the trademark, register it, and cancel the third-party trademark.
Got it. So it's not game over just because
Nope.
someone else has registered a name that you've been using.
Yep.
I mean, there may be some work to do. You have to dig in and see how much prospective right you have. Have you lost anything by, in a way, sitting on your laurels and not filing?
You have. So there's a couple different, different defenses to trademark infringement. There's, estoppel defenses. and acquiescence defenses. So, essentially one is that the person's been using the trademark for so long, typically 5 or more years, it would be unfair for the USPTO or a judge basically to say that they have to, throw away the trademark. They've accrued some rights in the trademark just by using the trademark for 5 years without anyone bothering them. Then there's the acquiescence argument where, the client should have or did have active knowledge of the third party infringement, but chose to, sit on their hands for a couple of years. And if that's the case, then you can be, stopped from enforcing the trademark at that point.
Got it. Cool. Thank you, Matt.
Yep.
Very good answer. Get a hold of us if you are in that situation. Be happy to help walk you through, explore, see how much we can help you do that. Phillip tried to do some more explaining. I think Phillip needs to come on and be part of this show. So a double patenting. I asked for some clarification. He brought the heat. A broad
yeah, he did.
I'm squirming over here. A genus claim with only a few examples. Okay, so chemistry and pharma. Okay, that's why we're not doing, right? Both usually represent individual inventors and for the most part are not inventing new medicines. But a selection patent would be when a species is found in the genus has unexpected advantages. Cool. Very cool. I like it.
Yeah.
What are my thoughts? I think that's cool. I think, so what I think the conundrum here is, patent 1 has this huge claim over, right, this chemical and all of these other, call it derivative works of that, right, Matt? And it's proven to the examiners that they have created it, and they've listed a few examples of what those derivatives could be. But and they explain how there could be hundreds, right? They found this new chemical and this new functionality, and what it does, and here's what a few of them are. But they're hiding the ball. They know that a specific derivative, a specific protein, whatever it is, to this chemical, when you make this specific one, boom, that is unexpected, different. It's way better. And I think what he's getting at is, unobvious properties, perhaps, as he's going on here. So maybe he still hasn't asked the question. I think the question here, and help me, is should a patent 2 be possible, where you identify that species, right, that one specific one, even though technically it was covered under the broad claim, the inventor has in a way discovered an unobvious species within that genus. I think touchdown. I think you're digging around, you're doing the work, but you're inventing, you're implementing, and maybe you find through hard work and effort, or just dumb luck and discovery, which is how inventions are. And I think you're there. You're at the bleeding edge. You're doing that work. I think it does make sense to award a patent.
Yeah, I mean, if you go back and just think of the purpose of patent law, I mean, that tracks, right?
Yeah, it really does. It really
Should be
does.
able to.
Yeah. And so if that's true, though, well, now that changes what that inventor or owner of patent 1 will do next time, is they'll probably try to list 30,000 pages of all the possible variants, right? Mm-hmm. So I don't know what that's all I could say. Philip, you're welcome to jump in with anything else. So it kind of does 2 things. If that were the case in the decider, it'll only happen once. Hopefully then from then on, patent 1 will have just this enormous list that seems burdensome as well. So it kind of cuts both ways. All right. Let's pull up out of the weeds a bit. Let's take a look over to our other question that came in through Reddit. And a sprightly 24-year-old female, she specified, is asking this question. Did we pull up like a picture and stuff? I don't know, but we don't. So here, hello. I'm navigating the process of starting a business. I'm in need of help in regards to registering my trademark. I'm allocating the little savings I have to start this project, and I keep getting quoted thousands for the trademark process alone, and I do not have the money to allocate that much toward getting it registered. A lot of people suggested that I do it myself, which is the route I intended to go. But if I'm really willing to value some guidance from somebody who's well versed in the process, what's someone to do that's really rubbing two nickels together, but they know they have a belief they want to go register something with the patent and trademark office? What do you recommend?
Yeah. So a couple different thoughts kind of come to mind. One, yeah, it is possible to file your own trademark applications, without an attorney. Totally possible. I've seen clients do it successfully. I've had more clients do it unsuccessfully, though. It's complicated, and it's easy to lose documents in the shuffle. The USPTO website is archaic, and it's just not very clear. It's very easy to screw it up if you don't know what you're doing. That's, I think, the main reason why you'd want to hire an attorney to do the legal work for you. I mean, certainly you could, use a document prep company to prep the application for you, but they're not going to be able to tell you whether or not the trademark is actually registrable. So it might be worth your time to get on a call with a trademark attorney, have them do what's called a knockout search. Take a quick look,
right,
looking for red flags, and assuming that they don't find any red flags, then at that point you may consider just moving forward with the application yourself, or hiring, one of these document trademark preparation companies to do it for you. That would be the cheapest route to do it. Okay. Alternatively, like firms like ours, we typically offer 2 levels of service for trademark registration. We do a comprehensive trademark workup. So search report, legal opinion, application preparation, submission, or, for clients who, don't have the resources to go all in on the trademark application work, or they happen to have a trademark application that is so unique that there's, very little chance of an office action at the USPTO. Those clients would, generally just pay us to file the trademark on their behalf. And that's much, much less expensive.
Yep. Nailed it. Boston law concurs. Get a search done first. Love it. Yeah. Yep. Do the whole kit and caboodle. Do what you can and start with the search. Take a look before you leave. And you say knockout. I've heard you say that. Walk us through. Is it good to be knocked out? Do you want?
You do not want to be knocked out. So, knockout means that when we do a search, we see a red flag for that proposed trademark almost immediately, right? Okay. So I consider a knockout search one that if I do the search, I put in the search terms, the goods and services, right? The software system that we purchased, that we paid for, does a more comprehensive look at the USPTO based on related classes of goods and services. It comes back, generates typically hundreds of different trademark registrations and applications for me to review, with the more significant or higher likelihood of confusion issues at the top. So typically within the first 50 trademark applications that I look at, or registrations that I look at, I'm going to know whether or not we can actually move forward with the application. If I have to stop and think about whether or not there's a likelihood of confusion between my client's proposed trademark and a registered trademark at the USPTO, the answer is likely yes.
There we go. Do you still have some clients, I'm just curious, to say, you know what, file it anyway, Matt? I know you're telling me this, but it's just brutal.
So a lot of clients are willing to roll the dice on the applications, especially when they're starting up a new business where they haven't invested a lot yet.
Right.
They might choose to roll the dice a little bit. But obviously, the larger the business, the more sophisticated the client, the more resources they have, the more that's on the line, they're going to want to go ahead and do the comprehensive trademark service, just to be sure that when they file the trademark application, we're not going to get any surprises.
Yeah, no, that's great.
Yeah. So I think my advice to this potential client is, I do think you should spend a little bit of money, whether it's just hiring an attorney for an hour to look at it and give you some feedback. That's what I would do. Perfect.
This is another kind of a softball question, but I think it's a good one because it's one of those ones that maybe some people out there are thinking, and they might even say the question wrong, as this one is, and it's innocent, and it's important to kind of clear this up. Do I need a patent attorney to file a trademark? Hey, no laughing. This is good. They're asking questions. That's a wonderful start. The answer is no. The answer is no. You don't need one. we talked about a couple of things today in that you could do it yourself. Don't do it. Likely should, in best case scenario, work with a trademark attorney to file a trademark. All right. Hey, it's all right. And some people get confused. I mean, we've got whole patents, but we offer a trademark. So is trademarks a kind of patent? Well, no, it's actually not. It's a separate area of law. And, that's why we've got Matt and I on the show. I'm a patent attorney. That is the lane I am in. Matt is in trademarks. Separate lane, protects different rights. Patents protect inventions, protect the ability for you to be the only player for a limited time to make, use, and sell that exact invention. Whereas trademarks, Matt, go on forever. Potentially.
Yep. As long as you continue to use them, keep them registered at the USPTO. And, another thing that I think is interesting too is that I think, the quality of services you're going to get from someone who is a patent attorney when it comes to filing patents is generally going to be higher than the quality of services you're going to get from an attorney who files trademarks, who's not necessarily focused on trademarks. So for those listening at home, to be a patent attorney, you have to sit for the patent bar. So it's a separate test. You have to have an engineering background, and then you have to sit for the patent bar, pass that bar in order to appear before the USPTO in patent matters. There is no such requirement on the trademark side. You don't need to be you need to be an attorney, obviously, but you don't need to be an engineer or have passed the trademark bar. That'd be cool if there was one, though. I'd love that.
It would be nice, I suppose. I think it's like a lot of different specializations, areas of law. Yes, it sounds like you can go to call it a generalist attorney, and they can say that they do trademarks, and that's legitimate. However, if they have not dedicated a lot of their career to it, they're probably going to miss a lot, and you're probably going to be underserved, in terms of what you're trying to do for your brand. And so someone like Matt who's dedicated his career to just doing trademarks, that is outstanding. That's going to be amazing service. You're going to get a whole lot more done in a short amount of time. Same on the patent side, although it's different. Not just any attorney can do it, can help and advise on the patent side. But quickly, one cool thing and one potentially cost-saving thing is you can hire a non-attorney, a patent agent, to help you as well on the patent side. Now, I'm not going to bash patent agents. They're just limited a bit. They cannot provide legal advice. They can't give you that, sort of lessons learned, what this is likely going to happen if this were litigated or if it goes to court. And so aside from that, they can still perform solid searches and do applications for you and walk along the side. So another option.
Hey, look what Dave says. He says, get a copyright registration for your logo.
Hey, gosh.
Don't do that. Don't do that. I've heard that referenced as the, and I know Dave's joking about that, but he's I've heard that called the poor man's trademark, is a copy registration. It's not the poor man's registration. Don't do that.
Well, I'm going to play dumb. In fact, I'm just going to be dumb. Sometimes. So copyright is art.
Yeah.
Protecting artwork. Now, a logo is art.
Yep. Can't
you protect that as art?
You can. You can protect it as art, so you can protect the copyright in the actual art itself, but you wouldn't be able to enforce it from a trademark perspective unless, of course, the person is using it in a commercial way that is presenting a likelihood of confusion with your registered trademark. So whereas you might be able to get someone to take down or prosecute them essentially for copyright infringement if they just rip off your logo and use it somewhere else or display it somewhere else, if you're trying to enforce the trademark against them from a trademark perspective, relying on a copyright registration, that's not going to work.
Oh, I love it.
So,
Mr. Bosman, thank you for this. Sage Burger King's bacon. Gosh, that's such a good line.
I like that.
So cool. Yeah, so it sounds like they kind of snuck out, had some trouble on trademark side, but we're able to win the day on copyright.
Yeah, I'd be curious to hear more about this. So some countries in the world work on a race, trademarks race to the trademark office.
Okay.
It's almost like a continental system versus the American system. I don't know if that's been harmonized in China, for example, but I can see a situation where somebody steals your Burger King trademark in China, right? And because they went to the Chinese trademark office first, they get the registration rights, and then you're left holding the bag trying to figure out what to do, in which case maybe they do rely on a copyright registration in that country to enforce the logo against the third party.
Very cool.
I don't know.
So I think the bottom line is if you want to be doubly protected, do both. You love your design. If you came up with it, it makes me want to go file this at the registry the copyright office. The blue and pink and green triangles. I'm going to go do it. Cool.
So Dave says they couldn't enforce on the trademark level, probably for that very reason. So they shut them down on a derivative cause of action, namely probably copyright infringement. That's cool.
Cool. Well, BK got it their way after all.
Absolutely. Yeah, Burger King loves to litigate trademarks.
Okay. Let's see if we get a good one here. We've gone through some of these already. Let's see here. We did that. This is similar to one we had before, but why not? This will be our last one unless we have any live questions. I'll check Avvo as well. So I invented a product. There is an expired provisional for it. I got a question about that.
Yeah. Did you really invent it then?
Am I still able to patent it myself? Okay, cool here. Cool. Invent a product. That can happen in private. Right? So there's not a lot of context there. Let's assume that was done in private. You invented it in your garage. There is an expired provisional for it. There's problems with that. Provisionals are not published. Therefore, there'd be no way for you to actually see a provisional application. The only time it shows up is when there's a non-provisional. Formal application is submitted, and then the whole thing is published, showing the priority back to a provisional. At that point, you can then go see the prosecution history, and then you can see the provisional. So a provisional that expired never gets published.
Really? So if I have a provisional patent and I never go forward with it, it just goes in the dustbin?
It's in the USPTO. They have it somewhere, but it's never published.
So they can reference it themselves potentially for obvious issue.
Here we go. I'm actually going to get to you. I'm going to educate you a little bit. So this is great. So long as two things big. If it was kept confidential, that's a big one. If you kept it during that year or whenever the provisional was pending, you didn't tell anybody about it. You kept it confidential, kept it to yourself, and as long as no one else has filed the same or similar invention or obvious, similar type of invention, you could still file another provisional. But this question tells me that they're seeing some documentation that someone else produced, right? Can I still patent it myself? I mean, they saw something else published that looks like their invention. And so, no, right? It's not novel. Obviously, it's not yours. It's someone else that invented it. And you wouldn't want to go through that and defraud the patent office and say you invented something that you didn't.
Right.
So the answer is no, but a good question for some cool discussion.
Cool.
Okay, let's crack over to Avvo. You have a couple sitting there. And I like the fact that it tells us where the questions are coming from. There is one trademark question. This person is from the UK.
Cool.
But they asked it in Brooklyn.
Okay.
So, how do I register a trademark in the US? We're a UK company. Whoops, wrong one. We're a UK business and wish to register a trademark brand in the US. Boom, simple.
Easy.
How do you do it?
Two ways. One, you just hire a U.S. attorney to file it for you here in the United States. If you're located in the United States, you might be able to just do it yourself too. But essentially, you would hire a U.S. attorney to file the trademark for you in the United States. If you have a trademark in the United Kingdom, depending on the services and the goods that you sell in the United States, how similar they are to those in the United Kingdom. When the trademark was filed in the United Kingdom, you might choose to have a UK attorney file the trademark in the United States using the Madrid Protocol. I don't think there would be much benefit in that particular case. So I would probably just, break the link between the old UK trademark and the US trademark and just file a clean one in the United States. That's my recommendation typically.
And let's say there was, prior use in UK. Do you still mention that, or is it first use in the US?
First use in the United States.
Got it.
Yep.
There you go.
So Yeah, your dates of use are going to be different, obviously, for the two countries. Generally.
Can you speak to the Madrid Protocol?
Yeah, Madrid Protocol is an international treaty that the United States and a couple hundred other trademark or a couple other countries, a couple hundred countries belong to. Yeah, I need water. Anyways, so yeah, it's basically a harmonization between different aspects of trademark law around the world. But it allows you to take one application from one country and port it over to another country or block of countries. Okay. So it's really a nice way to take for U.S. clients who have larger ambitions abroad. We file in the United States. We take that registration application within the first 6 months and port it to EU, UK, Japan, wherever, using the Madrid Protocol. And that's a much less expensive way of filing, that trademark, instead of filing it separately and having to hire counsel in all those different countries to file the trademark for you. You can have your U.S.-based counsel file the trademark in those countries.
Yeah. On the patent side, I usually kind of say the break-even is around 3 or 4.
Is that the PCT?
PC. Yeah, Patent Cooperation Treaty, Patent Cooperation Treaty.
Yeah, I'm giving my leather tongue to you, my cotton.
Yeah, it's like there's fees, and you got to pay to play the international ball game. If you're gonna be filing into at least 3 other countries, that's usually the break even of when it does make sense to do a PCT. Is it kind of like that for Madrid? Whereas if you're only doing 1 or 2 countries outside your own, maybe it's best to file directly and not mess around with the Madrid.
Yeah, Boslin makes a good argument here. If it's really, really important to you and you're a large company, you would file those individually using foreign counsel in each of those different countries. Generally, that's not the clients that we're working with. They're going to want the less expensive route. And, the thing about the Madrid Protocol that Dave kind of points out really importantly is that if the U.S. registration is attacked, you can lose the other registrations. So everything kind of comes back to that mother registration here in the United States. Generally that works out well for our clients because they're U.S. based. But if you're trying to port an application registration over from a foreign country where you're maybe no longer doing business, that's a big no-no.
Yep. Very good. So yeah, the kind of eggs are still in one basket if you did a Madrid. Okay, right on. A couple patent questions popped up. We've got it's kind of another kind of a high level question. We'll do it. We got some time, and then jump to our Shark Tank critique.
Cool.
So how can I get a patent on invention? I have an invention. I reached out to an attorney, but she never responded. Oh God.
Number one attorney sin: communication.
I'm looking for help. How to get a patent so I can move forward with my idea. Oh my gosh. I have the book for you. Seriously, send me an email. She even put her name down. Her name is Jenny. I won't say her last name. Email me, Jenny. There's no reason I put my email address in there. We can help. We will take we'll take a discovery call with you and explain our law firm. We're not just going to take your money right away. I think that's a really important first step for inventors to understand that not all attorneys are sharks, and neither are we. We want to make sure we can help you. It's a really important first step, and so that's what that link up above is all about. It's making sure that we're a good fit for you and you're a good fit for us. Also, it kind of goes back to my earlier point. So why we end up not having a lot of issues with clients is because of that early screening to make sure we're working with the right inventor, make sure it's an invention worthy of pursuing.
Sure.
These, checkpoints. Okay, you're the right kind of client. Okay, let's do some research. Okay, still looks good. Okay, now we'll start talking about applying for patents or trademarks. So it's a really methodical approach, and that's what I recommend is working with an attorney that certainly responds to you, but secondly doesn't just talk about taking your money right away. They want to make sure it's a good fit for everybody.
Yep.
All right. We reached the end of our questions. Let's go to our next big segment on the Shark Tank. This one is a pitch that came up a few months ago, season 13. I'm going to switch my microphone over here. So just give me a second. we'll try to watch about 4 minutes of it. And
Is that the magic number these days? 4 minutes and you don't get in
it's
trouble?
4. It's just, then I won't get flagged. But, our 2 live viewers, we don't want to lose our 2 live viewers. Beloved. We got David and somebody else.
Mm-hmm.
Okay. Here it is. Audio check.
Good.
All right.
Next in the tank is a company with an inclusive version of a product found in every home.
Hi, Sharks. I'm Rashid, and this is my beautiful wife, Intisar.
And we're here from Columbus, Ohio, seeking $75,000 for 7.5% of our company.
So, Sharks, when you have a cut, what do? You put a bandage on it. But as you can see, it doesn't match my flesh at all.
Sharks, we come in all different tones and hues, and there's no one size fits all when it comes to the color of our skin.
So that's why we created Bandages.
A line of flesh tone bandages made to match all individual shades.
So, Sharks, when you wear Bandages, people see you and not your wound.
We're on a mission to heal, uplift, and inspire the community around us.
Bandages has 5 different shades of flesh tone bandages, so whether you're chocolate and divine like Damon, or fair and fabulous like Lori, we have the bandage for you.
But we don't stop at just flesh tone bandages. Our character bandages were created to inspire our kids to dream big and become whoever they want to be.
All while healing them at the same time.
So, Sharks, you can't put a bandage on all wounds, but for the ones that you can, bandages have you covered.
So in front of you, Sharks, you have our amazing first aid kits, our flesh tone bandages, as well as our kids bandages.
So very cool idea. Okay.
Appreciate it.
But the bandages industry has to be a multi-billion-dollar business globally.
Yes.
Why wouldn't they just add this to their existing?
Yeah, that's going to be my
products?
question, honestly.
So they actually did try to do that. One of our bigger competitors came out with flesh tone bandages as well. Last year, when this happened, all of our followers, all of our supporters, they had our backs. They told the world that, no, it's already been done. And when that happened, we actually ended up selling out of our product. And we were doing this before it was cool to do it.
Yeah.
And I think because of that, people, they've gotten behind us and they've been extremely supportive. Last year, we had maybe 10,000 followers on social media. And within 6 days, it went up to 75,000.
Yeah, what happened?
Around that time, the country's in a little bit of social unrest. So people were already standing behind Black-owned, small-owned businesses.
What were your sales during that time?
During the 6 days, we had $130,000 worth of sales.
Just in 6 days.
In
Just
6 days.
in 6 days.
Oh, and that's when we sold out.
We sold out completely.
And to manufacture it takes some time. So we were sold out for about 3-4 months.
What were your total sales last year?
It was around the $140,000 mark.
So you just blew through your inventory right away.
Yeah.
When were you able to replenish your inventory?
Not until November.
2020.
So
Okay,
the
so
end of the year.
November 2020 to now, how much have you sold?
Probably like $50,000.
So what's the normal sales and where are you selling your product?
Our normal sales, honestly, is around $7,500 to $10,000 a month.
Right.
And we sell exclusively online, our own website. And it's all word of mouth. It's all social media.
Yeah, so you're all direct to consumer.
Yes.
But as of right now, we're not in any big box stores.
We're in the process of trying to get into some right now, which is why we need your help.
Have any reached out to you?
Yes. We actually, last year, we were reached out by Dollar General. But the only thing about that, we would have to sign an exclusivity deal.
What if we do?
We're going to counter for $100,000, the 3 of you guys, and you each get 7.5% a piece. Yeah.
What if we gave you a credit line for your inventory? You know, for another $75,000, which gives you a nice inventory run.
I'll agree to that.
I would agree to that.
15%, save 15%,
Sounds like a commercial.
15%.
Hello.
Okay, listen,
Right,
I'll
it's
match
true.
the 100K. 15%.
Can you come down to at least 25%?
I'm good with that.
25%.
We'll do it.
Got a deal?
They didn't want Mr. Wonderful's deal.
Yeah, no, that's great.
That is good. Okay, my first impressions, I think, is pretty cool. I'm glad they addressed right up front. 'Cause I know I had seen these before.
Yeah.
This is actually back 2020. It's one of those things like, gosh, yeah, as soon as you hit the market, that's the reason why a lot of people get patents, right? Is so
Sure.
that when they hit the market, they don't see this giant, big, probably let's call it, it's Band-Aid, right? Coming in with the exact same thing. In this case, a colored Band-Aid, I wish they would have talked about, could you have sought patent protection for that? The answer is no. I mean, a different color, only changing the color would be an obvious change. And so unfortunately, there likely was almost zero potential for a utility patent. There's be a really big stretch to go for a design patent on maybe the packaging or some really, finite details with respect to the adhesive or something like that, but really wouldn't stop Band-Aid from doing what they did anyway. It sounds like they were able to make some sales, and all the sharks perked up when they heard sales.
It's super cool. I was actually just thinking kind of about this the other night. I was watching Simone Biles do her floor routine, and she was wearing like a skin colored knee brace. And I was like, oh, that's interesting, because usually they're going to be black or tan or something like that, and hers was kind of skin tone colored. And I thought that was pretty cool. Yeah. They do have a trademark registration for roundages, so that's cool. I like the name a lot. It's kind of what we're trying to get clients to go towards, which is, find the name like Band-Aids and play around with it and add some suggestive element to it to make your own word. I mean, conceptually, it's a great brand.
That's awesome. Yeah, I think so too. And so they're selling online, at least as of the filming of that, Shark Tank pitch. If they were to go into big box stores, would that change? Would they need to go protect it a different way, or the way that they're selling?
No, I don't think so. They have a couple different registrations, one for the word mark Brownages, and then one for one of their slogans. They could probably come back and kind of round out that IP portfolio by adding maybe a design mark to protect the logo, potentially something like, they mentioned they do a lot of online sales. So, that online retail store application would probably be appropriate. I know I kind of hammer that every week, but it's a big blind spot for a lot of clients and a lot of clients' attorneys. They just don't realize that there's an online retail store class that protects real estate trade.
Yep. Very cool. Love it. All right. Well, we reached the end here of our normal broadcast. We're on deck for next week. I think we do have a guest. Looks like we got one more comment here from Mr. Boslin. They're into their packaging, so they could work on some trade dress protection as well. That's a good thought.
Yep. They have some clever packaging. You could do a trade dress application.
Yeah, that's good.
I'm actually working on a trade dress application right now for a coffee company.
Okay.
They do. They have a really unique store look and feel. So we're
that's cool.
Going big league with them, and we're doing some trade dress on the interior design elements.
Wow. So that does mean drawings, right?
Yeah, it means drawings.
Do you get your pencil and paper out, or do you have that hired out?
No, I'm not very good at that. So we hire that out.
Cool. So the trademarks can get technical.
Yeah. Oh yeah. Trade dress can get very technical. So
that's neat.
It's expensive to do it. It's a lot of work, and the USPTO is going to need some convincing, but we'll try it.
When you say convincing, does that mean you've got to come with either legal argument or some sort of a
potentially we'll have to make the argument that this is actual trade dress, in that it does have consumer recognition, right?
Okay.
So we might have to do some sort of survey evidence or something like that.
Yeah. Is there like a ballpark, like for a restaurant? I mean, if someone was just opening the restaurant, they would have almost zero chance, I would assume, of a trade dress protection. Is that right?
Yeah, they need to be in the marketplace.
Okay. Roughly how long? I mean, it's hard to say exactly, but what's a rule of thumb?
Well, I mean, that kind of gets more like acquired distinctiveness. So acquired distinctiveness isn't one of the elements that's required for trademark registration for trade dress. But if there's any doubt as to whether or not this trade dress actually does function as a trademark, namely connecting consumers to a product or service, then you could make the acquired distinctiveness argument at that point. That would require 5 years of continuous use of that particular restaurant layout, look and feel.
Yep. Love it. Cool. I'm going to put this in here as well. If anybody listening or those that are watching afterward, those are our email addresses there. I got Matt's information right there, matt.kulseth@boldip and jd@boldip.com. You're welcome to ask us questions. If you want to be a guest on the show or come on as a fellow attorney,
how much are we charging clients to come on these days?
0.
Okay, cool.
As a lot of our viewers know, we brought on non-clients before, and they can be a different breed.
Yeah. A lot of fun.
A lot of fun. It is, because it's awesome. Well, for Matt, for myself, wish you guys a great day. Yeah, enjoy your summer out there. We'll see you next week, Wednesday. Go big, go bold.
Go big, go bold at boldip.com.